Up next is Maslon trial lawyer David Suchar with a primer on choice of law arguments, which come up thousands of times each year, and how they can change the results in your case. David is going to discuss the states that preclude contracts from selecting foreign law and common approaches to resolving choice of law questions. He'll also cover why it pays to be the plaintiff when choice of law can be determinative. Please welcome David Suchar. Thank you.
Thank you, Jesse. Good morning, all. Choice of law issues can be the most important thing in a given case. The thought of whether you may win or lose may hinge sometimes on what state's law applies. Like Joe Ortega said, winning is something that we all want to do. And so if you want to win, it pays to pay attention to choice of law issues early on in a case. That is especially true if more than one state's law may apply to any given issue in a case, and if various states' laws may lead to a completely different outcome. So why does choice of law matter? Today, I want to give you a brief overview of some choice of law issues, some developments in choice of law across the country, and then, of course, to give you some practical tips and tricks on what to apply and what to do when you face complicated choice of law issues. Some of those include whether you want to try to attempt to become a plaintiff in the case, whether you want to try to file a declaratory judgment action, and some of the benefits you get from being the plaintiff and from being the first to file, even if the case is transferred out of that jurisdiction for convenience purposes. But the one thing I want to leave you with today, the most important thing, is that this takes preparation. It takes the knowledge of the substantive law at issue, knowledge of the choice of law rules at issue across the country in each jurisdiction, and then knowing how to take those rules and that law and apply it to win your case. So in 2015, just last year, there were thousands and thousands of cases where conflicts of law issues and choice of law issues were important, and where in some way the choice of law decided the case. Conflict of law and choice of law are both important topics, and the modern regimes that are developing across the country have led to more uncertainty. So the older regimes would, for example, put the law that was chosen by a court with the last event that occurred from which the lawsuit developed. That's not the modern trend. So the modern trend now is more toward a significant relationship test, where the court, if there is a conflict, will assess that conflict and will say, in a more holistic way, which one of these states should be the equitable result, should be the state that actually is the law that applies to this case. So in many of these cases, the outcome is dispositive based on the choice of law ruling. And so a lot of time is put into choice of law and conflicts of law fights. I want to give you an example from one of my specialty law areas, which is insurance coverage for defective construction. So I represent larger policyholder clients in cases across the country, often against their insurers. And for one of those types of scenarios, probably the most common that comes up in the construction realm, is whether a commercial general liability policy applies to a given loss. And in that area, there are so many different types of legal regimes, so many different types of potential outcomes. I'll give you an example. So under a CGL policy, the main question is whether defective construction can possibly be an occurrence, whether it can possibly be covered under an insurance policy. So that's the fundamental question. One way it's covered, the other way it's not, and you lose. Say you have an Illinois contractor, and the Illinois contractor does a project just over the border in Indiana. So you have a company based in one state performing in another. Well, if they are sued and defective construction is alleged, and then they go to their insurer to seek insurance coverage, if they seek it under Illinois law, it won't be covered. If they seek it in Indiana law, it probably will be covered. And this situation is repeated in states all throughout the country on this issue of law and on many others. So for example, in the western portion of the United States, In Washington and North Dakota, Washington probably has the best law for policyholders on this issue. Washington and North Dakota, covered. In Wyoming, it's not. And in other areas of the country, you see similar distinctions. New York has very stringent notice requirements, and New Jersey does not. I practice a great deal in D.C., Maryland, and Virginia, despite the fact that I'm located in Minnesota. And those states have dramatically different regimes in this area, too. So it's very important to pay attention to the different types of law that are at issue. And then, when it comes to choice of law, to think about what the choice of law regimes are to lead to the right substantive law. I thought to provide a few more potential facts which demonstrate some of the variations that can take place on a given case, sticking with the insurance topic. So you may have an accident that occurs in one state, an insurer based in another. The insured is based in another state. And you have policies that are negotiated and that are signed in one jurisdiction and delivered in another. And these things may seem like they're completely arcane and shouldn't matter to a court's analysis, but they do. These are all factors, depending on what the choice of law regime is in any given state, that will be outcome determinative, that again will decide which state's law applies, and which state's law apply, as we know, can make all the difference. In the products liability regimes, for example, you may have one state in which the product is manufactured, another in which it's purchased, and then yet another in which it's used. And so choice of law analysis sometimes can be important in that area too, to decide which one of those states' laws applies. But overall, you have an element of uncertainty that is introduced when choice of law regimes, you can't tell from the beginning what law is going to apply. But we'll get to, in a moment, some tips and tricks that you can use to get to the type of law that you want. So before I get to talk more about the contentious ways in which choice of law is decided when it's litigated, I thought to talk a bit about more when it's easy. And these are contractual choice of law provisions. So you often will have, in some areas of law, contractual choice of law provisions that apply, and courts will routinely apply them. So if the choice of law provision bears some resemblance, some relationship to the type of risk that's at issue, courts will apply the law. That's even more so when parties select the same state for venue or form as they do for the choice of law. There are some UCC rules that apply that also determine in certain transactions what law will be used. But some states make some types of foreign selection and clauses unenforceable. And so you have localizing provisions, for example. In California and Ohio, there's actually 26 states in the construction realm that have these localizing provisions where you can't apply foreign law to construction projects in those jurisdictions. There's also some states that for the Consumer Protection Act, they don't allow for you to try to use foreign state laws to enforce them in your contracts. But of course, the more interesting issue is what happens when choice of law is hotly litigated, when you have two parties who want as much as possible to apply different laws, because different results will occur if each law is applied. So there are several different approaches that courts across the country are now applying. And those approaches are completely different in the way they look to the types of law that apply. So you have the first restatement, which is the vested rights approach. And that approach is the place where the last event occurred. You have 10 states out of the 12, or 10 or 12 states that apply that principle. That's the old school approach. The much more common approach nowadays is the most significant relationship test. And so that is, again, taking a look at what the different relationship between the parties is and the cause of action, and deciding what is the state's law that will apply. In insurance cases, you have a couple other areas as well. A site-specific approach, they look to where the insured risk is located, or a uniform contract approach, where the contracting took place. But the modern trends in choice of law are definitely on due process rights for litigants, on a presumption that the forum law will apply. And in this area, dépeçage, which is a French word for dismemberment, is becoming a more popular way to decide these cases too. So courts will say, we can pick and choose which state's law we're going to apply to each individual issue. Most states have common law regimes, so court-developed law, and then some others have statutory choice of law regimes as well. So Now that you know the lay of the land on choice of law, the question is what to do about it. And the answer is that you may want to try to become the plaintiff in some cases if you can, because plaintiffs in this area have a huge advantage. Effectively, in federal court, have a large ability to choose the type of law that will apply. And by understanding the choice of law approaches pre-filing, you get a lot of these advantages. Some of them are the first to file doctrine, which I'll talk about in a moment, using declaratory judgments even when there may be a contractual obligation. Also, the Van Dusen case, there's a case that I'll talk about in a moment, which allows for the plaintiff to choose the forum, and then even if that case is transferred for convenience purposes, you still get the choice of law principles from the first court. And then there also is the thought that there may be false conflicts, and so a court will use its own law, but that law still may be beneficial to you as a plaintiff. Let's talk about first to file. So the first to file doctrine is a principle of federal comity, which means that courts can use it in their discretion. But if it applies, it means that when you file a suit in one jurisdiction, cases that are filed by similar parties in other jurisdictions may be dismissed. So because you, in effect, raced to the courthouse and filed first, you get a huge advantage. And that advantage is only exacerbated and added to by other federal procedural rules. And so that you have the Van Dusen versus Barak case, which stands for the proposition that even if you file a lawsuit in a jurisdiction, and the defendants are successful in transferring it for forum nonconvenience purposes to another federal jurisdiction, you still get the benefit of the choice of law rules of the initial jurisdiction. And what does that mean? That means that most often, the court using its own choice of law rules will decide to apply its own law, its own substantive law. And that's for a couple reasons. First, courts are apt to find that there is no conflict, that if it is not truly outcome dispositive, that they will continue to apply their own forum law, which they are obviously more familiar with than the other forum's law. And then, two, even within most choice of law analyses, courts are apt to find that their own state has a convincing interest and that their own state's law should apply. So it really leads to somewhat of a crazy outcome, which doesn't really make sense to me, but that you have a plaintiff who says, I'm going to file first in jurisdiction A. And I'm going to do so even though the facts and the witnesses and the documents may be in another jurisdiction. And then the defendant is successful in convincing a court that that's the case, and the case is transferred. But then that plaintiff still has the benefit of that better state's choice of law and most likely substantive law. In terms of how that first to file rule plays out, there are some exceptions to it, but they are not often applied. And so you have what is called an anticipatory suit exception and an exception for making settlement negotiations elongated in order to have a ruse where you file a case before the settlement negotiations are completed. But then again, those things are not very easy to convince a court of because they are so fact-based, and courts are going to presume that a party did not seek to make this ruse to file a case before the other party filed theirs. I thought to give an example of how these choice of law issues can play out in a case. And so a case that I litigated over 2.5 years is probably a pretty good example of how some of these choice of law issues can play out in real life. So I represented the Shaw Group and Chicago Bridge and Iron Company in a lawsuit against all of their insurers. And the lawsuit resulted from a large construction project and allegations of construction defects against my client. So it started with a $600 million construction project in Washington State. And my client was sued for $110 million with allegations of defective construction. The case was filed in a federal district court in Washington. My client is based in Louisiana. It manufactured the pipe spools that were at issue in the case in Louisiana. The insurance policy that it was issued in Louisiana. A lot of the policy negotiation and delivery and all of that took place, again, in the state of Louisiana. So what happened first is we filed our case in Washington as a declaratory judgment action because Washington law is much more favorable to us, as you might imagine, based on the facts that I'm explaining, than Louisiana law. And we filed first in Louisiana. A couple weeks later, the insurers filed their lawsuit in Louisiana, a competing lawsuit. The Louisiana court transferred the case to Washington, where it was consolidated with the other case. And because we had the benefit of the first to file rule, our case took precedence over the Louisiana case. And even though the federal district court in Washington eventually transferred the case to Louisiana for convenience of the parties and the witnesses, we had the benefit of Washington choice of law and eventually the benefit of Washington substantive law. So the Louisiana court looked to our allegations, extra contractual allegations, and determined that they should be based on Washington law because there was not a significant conflict between Washington and Louisiana law. And then also applied depicage, where it made the contractual law apply in Louisiana while the extra contractual cases proceeded under Washington law. And so what resulted was we were able to choose the law that we wanted to apply, and we were able to have the case tried then again in our client's backyard in Louisiana while applying the law of Washington, which was more favorable to us. So all in all, a very good result, but really only because of this crazy mix of procedural rules under choice of law. I thought to tell you about another benefit of depicage, which is that we got to litigate the case in Louisiana, which was a great time. And opposing counsel scheduled 4 depositions during Mardi Gras that I was able to attend. And so after it was all over, I went to Emerald's restaurant, heard that he was in the kitchen, and brought a group of people back there. And so this is us hanging out at Mardi Gras, me and Emerald Agassi. But that wouldn't be possible. It wouldn't be possible to have fun with Emerald at Mardi Gras and also have a strong case on choice of law without thinking about these issues beforehand. And so the thoughts that I wanted to leave you with before I go are that this is an area of law where it pays to think about these issues before you begin a case. Whether you end up being the plaintiff or defendant, it pays to think through first, what substantive law do you want to have applied? Second, what choice of law rules are going to apply in any given jurisdiction, and how will those choice of law rules potentially lead to the law that I want or the law that the other party wants? And so it is important to hire counsel who are familiar with the substantive area of law, who are familiar with the choice of law rules, and who know that choice of law may end up being the entire ballgame in a lawsuit. Thank you.